Good morning, everyone, and welcome back to the third and final day of the FTC's hearing here at American University Washington College of Law. We want to extend our thanks to AU for being such gracious hosts over the last few days, and also thank you to our participants in today's hearing and to those who have joined us in person or on the webcast. So the first day of the hearing really laid the groundwork for how to think about the economics and business of big data. Yesterday, we delved into the specific factors to consider when conducting an antitrust analysis of markets involving data, including a focus on online advertising, as well as the impact on privacy regulations on competition and innovation. Today, we're going to take a step back and with a couple of great panels, ask some broader questions about where antitrust enforcers, policymakers, and other stakeholders should go from here. I'll conclude with our final disclaimer that this event is being photographed and webcast with huge thanks to our tech team. And by participating in this event, you're agreeing that your image or what you say may be posted at ftc.gov or one of the FTC's social media sites. And this is we've given this disclaimer every day, and it is a privacy disclaimer, so it's also relevant to what we've been discussing. Thanks, and let's go to our first panel, Perspectives on Data Policy, moderated by Peggy from Anela of the FTC's Bureau of Competition.
Thank you, Katie. Good morning. Our first session today will offer various perspectives on data policy. We continue to navigate a challenging topic and strive to develop appropriate policy. Hearing from multiple viewpoints provides an important framework. To lead this valuable discussion, we are privileged to have representatives from a variety of uniquely relevant organizations. Our panelists will share their views regarding the intersection of big data, privacy, and competition, and will offer potential legal, regulatory, and policy next steps to address important data policy needs. The panelists will each start with a prepared statement, and then I will pose some questions for discussion. Also, for anyone in the audience that would like to ask a question, there will be someone from the FTC walking around with comment cards, so please just go ahead and write your question on the comment card, and it will be collected for the panel. Now, before we begin, I want to briefly introduce our panelists. First, we have Allie Bohm, who is Policy Counsel at Public Knowledge. Public Knowledge is a public interest advocacy organization that promotes freedom of expression, an open internet, and access to affordable communication tools and creative works. Next, we have Ramsey Woodcock. Ramsey is an assistant professor of law at the University of Kentucky College of Law, whose research focuses on consequences of the information age for the antitrust treatment of personalized pricing, dynamic pricing, and advertising. He also has a secondary appointment as an assistant professor of management at the Gatton College of Business and Economics. Katie McInnes is our third panelist. Katie serves as policy counsel on privacy and technology issues for Consumers Union, the advocacy division of Consumer Reports. Her work focuses on technology and the consumer rights to privacy, security, control, and transparency. Next, we have Eric Knoll. Eric is Senior Policy Counsel at New America's Open Technology Institute. He has worked on consumer privacy issues such as children's privacy and broadband privacy, as well as telecom issues like net neutrality and universal service fund. And finally, we have Tom Leonard, who is Senior Fellow and President Emeritus at the Technology Policy Institute, where he works on privacy and competition issues. So we'll go ahead and get started. If Allie, you can go ahead and begin our discussion, please.
Thank you. Thanks for having me today. It has become virtually impossible to meaningfully participate in society without revealing our personal information. Most essential, entertaining, and useful services demand personal data that are then used to build detailed profiles of us and to deliver targeted advertising. Service providers follow us around the internet, scooping up, and across devices, scooping up more and more data to come up with more precise ways to sell us products. Consumers are dissatisfied with this state of affairs. Some find it abusive that privacy is the price to pay to participate in modern society. Some find it frustrating to be paying twice, once with their data and once with their dollars. And nearly all are outraged by data breaches, hacks, revelations of corporate and state surveillance, and other social and political scandals. Consumers in the United States want more control over our personal information, and we demand privacy protection. It's clear that the status quo is not working, and I think that's likely part of why the FTC is having these hearings today. So what are some solutions? Some advocates have argued for stronger and more creative antitrust enforcement. In fact, some have said that that is the solution. It is public knowledge's view that while antitrust has a role to play in protecting competition and consumers' privacy in the digital age, it alone is woefully insufficient. Here's why. First, competition could incentivize companies to differentiate by innovating in privacy protections. However, it could just as easily promote more aggressive data collection in order to give companies a more competitive edge. Second, any settlement after an investigation or any consent decree as part of a merger approval can only be a primary tool for protecting privacy so long as it is enforced on an ongoing basis, which would require substantial FTC resources. I probably don't need to tell the people in this room that the FTC often prefers structural remedies such as asset divestiture rather than remedies that make it have to monitor companies on an ongoing basis. Third, antitrust may just turn one privacy offender monopolist into several smaller privacy offending competitors, none of whom have sufficient market power to be considered dominant and to fall under antitrust enforcement going forward. Fourth, the consequences and impacts of many privacy violations are the same regardless of the size of the company involved. So in most cases, antitrust simply can't get involved if it's a non-dominant player. It's also not clear that the FTC can step in when it comes to traditional backward-looking antitrust enforcement. As this audience likely knows, single-firm conduct is typically only a violation of antitrust law to the extent that it unreasonably restrains competition. Despite antitrust's focus on consumer welfare, it will not typically address negligent or risky behavior by dominant firms, even when that behavior harms consumers. So what can the FTC do? Narrowly, in antitrust land, the FTC should use antitrust enforcement to encourage non-price competition, including competition based on different levels of privacy protection. Antitrust should recognize that one of the harms of market dominance may be the ability to coerce consumers to provide more personal information in return for essential or unavoidable services. In addition, the possession of data could be considered as a potential barrier to entry during merger review, even when the merger would not otherwise have significant vertical or horizontal competitive effects. The FTC could also use its UDAP authority through case-by-case adjudication to figure out whether third-party trackers trackers on third-party websites are deceptive when they track folks all around the internet without those individuals' knowledge or consent. The FTC could also conduct a 6B study of how platforms are using data and how their data affects competition. The advantage of a 6B study is that it results in a published report. So if it turns out, as public knowledge postulates, that antitrust is not entirely the solution to the problems of competition and privacy and big data, there will actually be a record to help build other solutions. Finally, the FTC should advocate with Congress for passage of a comprehensive privacy law that would imbue the agency with much-needed resources and with rulemaking authority. This is not a novel idea. Even during the golden age of antitrust enforcement in the 20th century, antitrust was never seen as enough on its own. The same period that saw robust antitrust enforcement also saw the first wave of consumer protection laws. I'm happy to go into detail about what public knowledge would like to see in any comprehensive privacy legislation during the Q&A. As a final thought, my organization strongly supports competition, but competition is not always a per se good. So for example, there's not enough competition in the pharmaceutical industry, and prices are way too high, but that doesn't mean that we want Joe Schmo on the street selling fake drugs. He might be able to sell them more cheaply than you sell real drugs, and it might drive down prices. But the costs to society of having fake drugs on the market are not costs that we as a country want to bear. And the role of regulation is to keep bad actors like Joe Schmo off of the market. I think the same thing can be said in privacy land and in data and big data land. We don't want nefarious actors doing things that we as a society wouldn't want with our data, and the role of regulators is to keep that from happening. So I appreciate the opportunity to be here, and I look forward to discussing more during the Q&A.
Thank you, Allie. Ramsey, if you would like to go ahead and give your prepared statement.
Thank you. It's great to. Thank you. It's great to be here. We need to focus more in antitrust on issues surrounding the exploitation of data than we have so far, and perhaps shift the focus away a little bit from antitrust issues surrounding the extraction of data, because that may well give us a sense of the way forward here that's very different from what's been put on the table so far. So data allows firms to know more about their customers and thereby to extract more value from them. It allows them to tailor prices to their customers through personalized pricing. It allows them to raise prices when market demand surges as part of dynamic pricing, which has spread over the last 10 to 15 years from one side of the economy to the other, from Disney World now dynamically pricing access to its parks, to Broadway shows, dynamically pricing tickets, to Amazon, dynamically pricing hundreds of thousands of products and changing those prices hundreds of times per day. Through targeted advertising, it also allows firms to increase the willingness of consumers to pay for products that, absent the advertising, they may not, in fact, they would not in fact prefer. So this exploitative effect of data should be the key focus for antitrust going forward. The reason why it has not been the key focus for antitrust is because the exploitation of data is not in itself anti-competitive. And it's a long-standing rule in antitrust that a firm's decision to raise prices in and of itself is not an antitrust violation. And so on a superficial level, it looks like there's no way for antitrust to respond to this vastly increased bargaining power that firms now have vis-a-vis consumers as a result of the fact that they now know so much more about them. It turns out, however, if you look a little bit more closely, that there is a very important role for antitrust to play in this story. Because while data allows firms to increase the amount of value that they extract from consumers, competition places a ceiling on that level of value that firms can extract from consumers. If you think about, take any market, whether it's concentrated or not, competitive or monopolized, if you think about what data does, it allows firms to figure out how much they can raise prices without alienating their consumers. So it allows them to extract more value from consumers for any given level of competition in the market. However, the more competitive a market is, the less the firm can raise prices, and so the less value it can extract. What that means is that the data revolution gives antitrust enforcers a mandate to deconcentrate markets, to expand competition across the board, because only by doing that can we place a ceiling on the amount of value that firms can extract from consumers through data and lower that ceiling to offset the increase in value that data is allowing firms to take from consumers. What that means is, while antitrust cannot attack individual exploitative practices as anti-competitive because they are not in themselves anti-competitive, the raising of price is not in itself anti-competitive, by ramping up enforcement against genuinely anti-competitive practices, practices that result in markets being more concentrated than they need to be, antitrust enforcers can create the competitive environment that makes it harder for firms to exploit, to successfully exploit the data advantage that they've gained over the past few years. So what this means, in other words, is that data gives us a reason to go back to the enforcement levels of the 60s and 70s. It gives us a reason to challenge every horizontal merger. It gives us a reason to challenge every vertical merger. It gives us a reason to pursue firms based purely on their size, as was done quite commonly in the 60s and 70s in everything but name. And once we do that, that lessens the need for sort of the complex considerations regarding limiting data extraction and privacy that so far have preoccupied us. Because if the data is no longer useful for exploitation purposes, maybe we can be less concerned about its extraction to begin with. Thank you.
Thank you, Ramsey. Katie will now give her statement.
Thanks, Peggy, and thank you for the FTC for hosting these hearings and giving us the opportunity to speak to you here today. So there's an obvious power imbalance between consumers and companies, and there has been for years. But unfortunately, the amount of data that companies can now mine, collect, and use on consumers has exacerbated this imbalance. We at Consumer Reports are working hard to make sure that that imbalance is ameliorated to the extent that we can help, but consumers really do need a federal data privacy law that will give them the protections that they need and really deserve. This data protection law would have reasonable data minimization that's tied to context and consumer preferences. We'd also like for permission for extraneous data collection, along with detailed information about data security practices, strong data security practices, ways for consumers to get access to their information, and robust enforcement. And of course, any federal data privacy law should include increased resources and rulemaking authority for the FTC. In addition, we think a data privacy law would not preempt stronger state laws. It should create a floor and not a ceiling. Our states are laboratories of democracy, and we don't think that we should prevent innovation on the state level to further protect their consumers in the ways that they see fit. Consumer Reports is trying to help consumers evaluate the privacy and security choices that are presented to them. But unfortunately, privacy policies are way too long, full of legalese, and often buried on websites and not easy for consumers to evaluate one against another. For this reason, Consumer Reports introduced the digital standard in March of 2017. And this is our understanding of what is best as far as data security and privacy practices for products and services for consumers. And we started evaluating products under this standard this year. And we've seen a huge response, both from companies and from consumers. However, this effort depends on transparency, which is one reason why we're pushing for any kind of privacy law to include requirement of SEC-type disclosures from companies as far as their data practices and privacy policies. That way, these policies could be read by those who are already reading them, and they would have more information. Regulators, policymakers, reporters, and groups like Consumer Reports would be able to fully understand what companies are doing with consumer information. And we also support any effort to get to this endpoint, but we understand that at some point, consumers just also need in-the-moment disclosures as well, which is why we appreciate this layered approach. However, we'll get into more of nuances of what we think about the data privacy law today in this panel. Thank you.
Thank you, Katie. Now Eric will give his statement.
Morning, everyone. Thank you to the FTC, and thank you for Peggy for putting this together. Since I'm the third consumer group to speak, I'll try to not repeat things and perhaps can keep this relatively short. But OTI, Open Technology Institute, my organization, has been thinking a lot recently, particularly about the competitive market, the level of competition, particularly among social media platforms, but also just among big tech platforms in general, and thinking about ways that we can sort of, chip away at that a little bit without necessarily, doing something like breaking up a company, for instance. But essentially, we're seeing this growth of a couple large social media tech companies who are able to more and more collect data and be able to, for lack of a better word, exploit that data. And what ends up happening, or what has happened, is basically they end up crowding out smaller companies that could sprout up, or companies start with the idea that they would get bought up by one of the bigger players. And so you end up having fewer and fewer companies with more and more data, and then you end up creating this system, particularly for businesses and minority communities of color, low-income businesses that feel forced to use these platforms to reach their customers, and they can't necessarily expand beyond those because there aren't really many other options. So obviously there are a lot of ways we can go forward with this. Antitrust is one of those ways. I'm not an antitrust expert, so my understanding of competition is probably a little less nuanced than some of my other panelists and some of the people in this room. But so, obviously one of the more extreme ones is to break up companies, which, as I've said, we don't necessarily support, certainly not at this time. Particularly because how would that work? How would you break it up? It's not like AT&T where you can break it up into long distance and local. So, there's a lot of questions there that may end up making things, or there are a lot of things there that might end up making things worse than better. Another option is to make behavioral advertising less appealing and less profitable. That way, smaller companies that have less data and have access to less data could compete more on a more level playing field with contextual advertising or subscription models or something like that. That's also not necessarily something we'd like to do, at least in the immediate term. The option that my organization prefers, which my director spoke about yesterday on the Revenues panel, is emphasizing data portability, which allows users to port their data between services to allow a competitive service to take advantage of the data that someone has already put into the world on another platform and just move it to that platform, be able to target advertising based on that information. But then also platform interoperability, which is not to be confused with data interoperability, which is about making sure that data can be, there's like a standard for the data to be ported. Platform interoperability is more about being able to use any platform and talk to and communicate with anyone else on any other platform. We have an example of this right now in the Fediverse, which has services like Mastodon and PeerTube, where they basically they all interact with each other, that you can communicate across the platforms. We obviously don't see that today because companies are trending toward locking down their services and their data rather than opening them up. And I'll just say a couple things about privacy, substantive privacy rights. Obviously a lot of us are thinking about and talking about comprehensive privacy legislation, but also what the FTC can do without any new legislation. The three things I just want to emphasize right now is data minimization, which Katie covered, the right to control and access and delete and modify data, and then enforcement of whatever, strong enforcement of whatever privacy regime we end up coming up with. And I will leave it at that.
Thank you, Eric. And now Tom will go ahead and give his statement.
Well, thank you, Peggy, and thanks to the FTC for inviting me to speak. I think this has been I've watched some of the hearings in the last couple of days, and I think they've really been very good. I want to make two related points. The first one may seem obvious, but probably needs to be said fairly often, is that policy makers need to do the necessary analysis to make sure that privacy policies actually do produce positive net benefits. And as part of that, and this is particularly important for the FTC given its mission, is assessing the competitive implications of privacy policies. Competition policies generally have a strong economics underpinning, and while there's now more debate on the subject, I think there's still a fairly widespread consensus that antitrust should deter activities that are harmful to consumers. But privacy is behind antitrust in terms of incorporating economics and evaluating the relevant trade-offs and doing the analysis necessary to show that the proposed policies have benefits greater than costs and therefore actually do improve consumer welfare. So, for example, we know that collecting and analyzing large amounts of data is the basis of much of the innovation that's occurred on the internet over the past 20 years, and many of the benefits of data are realized when data are reused, combined with other data sets, used to answer new questions that were not anticipated at the time the data were collected. But many privacy policies target those practices and restrict the collection, use, and sharing and retention of data. And we need to more rigorously assess the cost and benefits of those policies to know whether they actually make consumers better off. If markets are operating properly, if there's no significant market failure, there's no reason for the government to intervene in the first place. And we know that consumers willingly exchange personal information for the resulting benefits, despite what they say in surveys. And we also know that firms suffer quite significant financial repercussions when they experience data breaches, which gives them an incentive to put the necessary resources, or certainly a lot of resources, into avoiding them. So are these factors consistent with the notion that the market for privacy is subject to serious market failure? That's a question that needs to be analyzed in more detail. We know that consumers routinely exchange their information without reading and understanding privacy notices, suggesting that most consumers don't find it rational to spend the time and effort to do so. Is this consistent with various transparency notice and choice proposals? Perhaps most importantly, I think this needs to be the starting point really of most analyses, we need to define more clearly the privacy harms that are being targeted and that we want to avoid. The recent informational injury workshop that the FTC held and the summary memo that the BE and BCP staff wrote, I think, were a good step in that direction. And this is critically important because benefits, by definition, consist of a reduction in harms. If there are no harms, there can be no benefits, only costs. And while we all know that identifying harms is difficult, it's not enough to simply assert that collecting information or sharing information with third parties is harmful per se. Now, on the competition front, I think more economic analysis would help illuminate the tension that exists between privacy regulation and competition. Some of these issues were discussed in the last 2 days. There's quite a bit of theory and evidence that many privacy regulations favor large incumbents and may make entry by new firms more difficult. I think this is borne out by the early experience with the GDPR, which imposes large upfront compliance costs and appears to benefit the large tech platforms, and we see smaller companies pulling out of the EU in reaction to the costs of complying. And on the consumer side, it was referred to yesterday as well, there's a paper by Campbell, Goldfarb, and Tupper, which is it's a different argument, but it kind of reinforces the other argument. Focusing on transactions costs shows that the opt-in consent regimes favor large firms that offer a range of services because it is easier. There's, in the economist jargon, smaller transactions costs for consumers to go through the procedures once with a large company offering a range of services than with many smaller companies. And increasingly, regulations such as the CCPA are being adopted that make it more difficult for data to be sold or otherwise transferred to third parties. And regulations like these can also be a barrier to entry because firms entering a market often need data on characteristics and preferences of potential customers before they can get started and collect data of their own from actual customers. And these regulations can also raise costs for data brokers, which also can be a barrier to entry. Data brokers can realize economies of scale and scope in data that can benefit entrants and other smaller companies that can't realize those economies on their own. And finally, in addition to making it difficult to share with third parties, can lead to companies to integrate with other companies in a way that would be otherwise inefficient and therefore may lead to antitrust concerns. Thank you.
Thank you, Tom, and thank you, everyone, for your statements. Why don't we go ahead and jump into the questions now? I would like your thoughts on whether data-driven pricing threatens consumer welfare directly by enabling firms to extract more surplus from consumers for any given level of market power, and if so, whether there is anything that the antitrust laws can or should do about that. Ramsey, would you like to lead us off on responding?
Yes. I think that the answer to that question is yes. I mean, it really flows from sort of basic economics involving differentiated products. I mean, think about an airline in the midst of a price war in a highly competitive market. It's still able to charge more to first class passengers than to economy passengers, and that's because products are differentiated, if only in brand name, which consumers care about, however rational that might be for them to do so. And the result is that every firm always has a little bit of power over price. And as a result, the more data firms have about their customers, the more they're able to exploit that data to raise prices for those customers who turn out to be willing to pay more, regardless of how competitive the market is. And that's why I like to think about data as really presenting a sort of second dimension of market power, where the first is determined by the level of competition in the market, and the second dimension is determined by the level of information you have about your customers.
I think the question basically is about price discrimination, which also was covered by several people in the previous couple of days. And it's true that price discrimination transfers some, and in the case of perfect price discrimination, all of the surplus from consumers to producers. But price discrimination also is efficient in terms of increasing overall welfare when it increases the total output of the market. So particularly in the case of products with high fixed costs and low marginal costs, one example is airline tickets. Price discrimination may be necessary for the good to be produced at all. If airlines couldn't price discriminate, we would have, it's not like we wouldn't have any airlines, but we would have fewer flights. And lots of goods in the digital economy and the information economy, like apps and software, also have high fixed and low or even zero marginal costs. And price discrimination may, in fact, be essential for those goods to be produced. Also, price discrimination, I think, contrary to what's sometimes said, I think price discrimination generally favors lower income consumers because it really involves charging prices based on a consumer's ability to pay. A consumer's ability to pay is in general related, it's charging on the basis of a consumer's willingness to pay. Consumer's willingness to pay in general is correlated with their ability to pay, which implies that price discrimination otherwise, other things being equal, is going to charge lower prices to lower income consumers who otherwise might be unwilling or even unable to purchase the product.
If I could just jump in. First of all, this use of first-degree price discrimination or dynamic pricing is a harm to the consumer, first of all, because it's these decisions are made about the consumer based on data collection, which they did not agree to, and is rather privacy invasive. Second of all, they don't have any sort of transparency for how these prices were calculated. And we've seen in markets that this not necessarily, dynamic pricing of different products is not necessarily a good result. We recently did a report on car insurance pricing and found that people in a lower income community were being charged more for their car insurance because they used a proxy of a zip code and decided that they were more at risk based only on their zip code, which happened to be a majority neighborhood. So this is not necessarily a good. Second of all, having dynamic pricing diminishes the consumer share of the consumer surplus, which is not helpful either. And third of all, consumers are unable to compare prices, which is one ways that we have a competitive market. If I can't compare one price of an airline ticket to another because they're all raised because I've been searching for airline prices to New York all day, that does not allow me to actually choose which airline would serve me best. Thanks.
Well, just to put a finer point on that, Katie, and sort of in conversation with Tom here a little bit, price discrimination, when it's imperfect, can benefit consumers, right? It can bring consumers into the market who otherwise would be priced out of the market at a higher uniform price. But as price discrimination becomes more perfect, and that's where we're heading, that's the whole point of the data economy, to personalize the price and get it up to willingness to pay, the consumer's benefit from that goes to zero. And so while it's correct that perfect price discrimination is efficient, all of the efficiency gains go to the producer and zero go to consumers. And under antitrust, we operate under a consumer welfare standard, not a total welfare standard. So a policy that drives consumer welfare to zero is not in antitrust interest. And just to put it in intuitive terms, think about this hypothetical disadvantaged consumer who's brought into the market through personalized pricing. If they're charged a price exactly equal to their willingness to pay, which is where we're going with personalized pricing, by definition, by economic definition, they are indifferent between having access to that product and not. They get nothing from it.
So I feel like I need a mic drop to follow Ramsey. So I'm a little intimidated, but I do want to add one thing about sort of who is benefiting, and price discrimination, probably means lower income folks can afford to buy things. I think that's the data sort of demonstrate that that's not always true. And so Katie gave us one example that I think is really good. Here's another one. The Wall Street Journal recently did a study of price discrimination, and they were looking at staples, and if you were in various zip codes, what it would cost to buy various products there. And they found, unsurprisingly, that if you lived closer to a rival store, you were getting lower prices on staples.com. It's rational, right? They want you to buy online from them instead of going to the Office Depot down the street. It also turns out that the people who lived near the rival stores tended to be higher income. So folks who lived further from stores, who were getting higher prices, were also poorer folks. And so I think there is not only everything Ramsey said, but there's also a real risk of further entrenching the economic divide in this country, because the people who do live close to stores tend to be the people who live in wealthier areas where stores want to come.
So switching gears a little bit, do you think businesses will start competing, or in fact are already competing, for customers based on consumer privacy choices? And if so, how do you think this will affect privacy practices? Eric, do you want to start us off?
So we do see a rise in the use of consumer privacy protective practices, such as the use of ad blockers. It's about to reach 30% this year. And more consumers have been interested in the use of a virtual private network since Congress rolled back the broadband privacy rule that the FCC passed in late 2016. But we also, here at Consumer Reports, where we released the digital standard, we've seen a great response from businesses where they responded within the next few days after we introduced the standard to see what kind of criteria we were using and when we would be rolling that out for all of the products that have connectivity. But we've also seen consumers been really interested in our evaluations of products based on privacy and security because they don't have the tools available to evaluate these products. So I think that we're only going to see a rise in consumers being interested in products that preserve their privacy and data security. We've seen a great use of home products like Alexa and Google Home and the rest, but at the same time, consumers are concerned about how much these products are listening to them. So they're interested in these accessibility and these convenience products, but they're also really, really interested in how much their privacy is protected. But unfortunately, they just haven't had the tools to evaluate these products. So that's one reason why Consumer Reports has entered into this process of evaluating products for privacy and security. But that's also another reason why consumers need a data privacy law in order to even the playing field a little bit here. But we've also seen that consumers are asking for more from their companies. We've seen a drop-off of a membership for Facebook after the Cambridge Analytica scandal. So breaches of consumer data do have a repercussion for the company, especially in consumer trust. So we see that this will only continue to rise as consumers become more and more aware of how much they're being tracked and how much their on and offline activities are being correlated in order to create, to make decisions about them and their buying practices.
Yeah, I'll jump in here really quick. I think there are certainly lots of privacy protective services out there. Spider Oak for cloud services, Proton Mail and Fast Mail for email, Signal for communications, DuckDuckGo for searching, and so I think we will probably continue to see these privacy protective competitors sprout up. As I mentioned before, it's sort of hard for a privacy protective social media network to sprout up for a variety of reasons. But I think in terms of whether, how could we get more competition, consumers, I heard this a long time ago, that consumers are not very good at internalizing like potential harm in the future. People still smoke even though there's a potential that they might get lung cancer when they're older. And the same thing is sort of true with privacy, where if you're looking at a free service that you have to give a bunch of data to, or you're looking at another service where you pay $10 a month or $5 a month or something, but it protects you from privacy intrusions by ideally not collecting data about you, or collecting a very minimal amount of data. It's a lot harder for a consumer to look at that and say, well, that's worth X number of dollars to me, even though in the future, if you go with the free company and they get breached and information gets leaked about you, it may lead to identity theft, it may lead to a variety of other harms, secrets about you getting leaked that you don't want to know, that you don't want the world to know. And so it's hard for consumers to actually make that comparison. And I think maybe there's just a way to be more explicit about it, and maybe the advertising for these privacy protective companies has to be clearer about that. I don't know. But I think it's, as a consumer, and me in particular, it's hard to part with dollars out of my wallet when I can, just go with a free service and sort of pretend that there are no potential harms that could come from that collection.
Actually, if I can jump in, I mean, it does seem like there is a serious market failure here when it comes to privacy, but it also is. I mean, it also seems like consumers recognize that that not being completely private with their data does benefit them, and so which is why I've tended to focus more on sort of increased competition in markets as being a potential solution to this problem, rather than increased privacy protections. Because in very competitive markets, data can't be used against consumers so much. But firms still have access to that data, and they can use it to do the sort of beneficial things with data that that we all love. Computers being able to serve us without us having to ask them, and so on.
And I'll just add that I've done a lot of work a lot of us have done a lot of work in broadband privacy, and one thing that we haven't seen in the ISP market, if you can call it that, is no one competes on privacy, even in the wireless market, where people tend to think that is at least a somewhat more healthy competitive landscape. And I found that interesting in terms of, if you have a competitive market, you will probably get some providers that will compete on privacy, but we don't see that in the ISP market.
What is the role of interoperability in addressing big data, privacy, and competition? Allie, do you want to start us off?
Sure, so this will be relatively brief. Interoperability is super important, and it can be helpful for allowing new players to enter the market and for individuals to leave privacy violative services. So if, for example, Facebook were interoperable with this fantasy, really privacy protective social network, you might actually go over there if you could still, message your Facebook friends from there. Because you could leave you could leave in, without sacrificing your contacts or your content from Facebook, right? But it's not a panacea. So email is a great example of something that is fully interoperable. And yet the vast majority of people are on Gmail, whether that's because it has more storage or it's the best product. I don't know, but people have gravitated there and given it, a disproportionate market share. So I think that there is a risk that even if we have full interoperability, we're still going to have certain players emerge as dominant, and it's not actually going to solve all of the problems in this space.
So yeah, I've mentioned this in my opening, and so separating out data portability and data interoperability. Data portability is a much easier question to answer. I think it's easier to sort of, for lack of a better term, or legislate it from the top down and say in some way that there has to be some kind of data portability option. We see it in the GDPR and we see it in the California law. And it's really, the benefits there is to make sure that users, if they want to, can move their data from one service to another without having to reestablish their entire social lives on a different service. And the provider, the social network provider, gets the benefit of all that data to then be able to target that person and potentially other people. And so portability is relatively straightforward. There are some thorny issues there. Partially, something that we may get to is, what data should you be allowed to move between services? What data shouldn't you be allowed to move? Should that data be deleted from the social network that you're moving it from? There's lots of, in the weeds sort of questions that come with that. But it's the platform interoperability that's a lot more tough, a much tougher issue. So a lot of it has to do with protecting privacy versus allowing interoperability and portability to a certain extent, depending on what you're porting out. So my director, Kevin Bankston, talked about this yesterday. What about your social graph? Can you port that data out? Is that something that should be interoperable for the user to be able to move? And so what you're talking about now is data about other people rather than just data about you. And so that gets into the question of what data can you move? And Professor Pasquale said, put forth the argument that whatever data I upload, I can then also move between services. And I think that's a decent starting point, but I don't know if that necessarily gets to the full issue, because obviously Facebook makes a lot of inferences about us and uses data in a lot of different ways that we don't necessarily know. And that's why I couple the data portability and interoperability issues with the right to control access and amend and delete your data, so you can actually see what they have, and then that way you can make an informed decision about whether you want to port all of that data or not. Unfortunately, what we've seen recently, because of Cambridge Analytica and some other issues, that social network providers are actually locking down their data more than they are opening it up, and that is in part due to the public's reaction to Cambridge Analytica, which was swift and intense. And so that was partially due to the ability of users to port their social graph and be able to use that information elsewhere, and that's something that Facebook actually fixed many years ago, and then is actually now becoming more locked down as a result of the Cambridge Analytica scandal coming to light. So yeah, I think that data portability and interoperability are, portability is the low-hanging fruit, so to say. Interoperability is a much more difficult issue, but I think they all should be, both of them should be considered going forward in terms of, you know, FTC hearings and fact-finding and that sort of stuff. So, thanks.
So I think if you look at something like portability, you need to start out by asking yourself, well, what's the purpose of portability? The purpose of portability is presumably to lower switching and to lower switching costs. So whether it's a good idea or not really is dependent on the context. So, for example, I think for most consumer facing applications, retail, you know, the fact that I might not port all my data, you know, my 10 years of purchase history from Amazon to somebody else does not prevent me from buying from another retailer. There's really no switching cost to doing that. So the value, it's sure there would be substantial costs and a portability requirement, and I think the benefits would probably be minimal. There may be other apps where there may be other situations where it is important. If you had a medical app where there were a history of a history of medical treatment or various things was important, then you know that would be a barrier to switching. In terms of something like Facebook, I don't even quite understand how it would work. I mean, you could port yourself, but you can't port all your friends. I can't, and if you're not going to be able to port all your friends, I don't see why.
You can port your friends. That was the Cambridge Analytica scandal.
You're not porting them to another social network. You're not.
Well, that's actually how most of the social networks started, was they said, hey, can we have access to your email account? And we're going to send emails to all your friends asking them to join this social network. And I think one of the tricky questions with data portability is, do I get to port my social graph? And if it's Facebook, if I'm friends with Eric, is that Eric's data that we're friends? Or is it my data, and do I get to port it? And that's one of the tricky questions about whether portability is going to sort of be effective from a competition enhancing perspective. So I think you're stepping on a very live question here.
I suspect, I mean, I don't know, obviously, but I suspect a lot of people would be unhappy if they found themselves ported without their permission.
I think you're right. I think that's one of the issues.
You're talking about signing other people up for new services.
Well, you're porting all of their data, you know, put aside Cambridge Analytica, it's just as a common practice to say, well, I want, you know, just seems to me there are problems with it.
Just wanted to point out that even if we solve, so sort of data portability is about solving the kind of economies of scale problem with sort of data intensive businesses.
I think it's about reducing
right?
switching costs.
Right, but by reducing switching costs, you sort of make these markets contestable in some sense, right? Because there certainly are huge economies of scale associated with data. I mean, that's why Gmail is the dominant email platform, because the more you know, the more users you have, and the more you know about them, the more you're able to sort of filter out spam and protect your email servers, and that's a big part of why Gmail has gotten so big. And so portability sort of, it won't necessarily deconcentrate a market because you still have those economies of scale and data, but it'll make the markets more contestable so that, if some other platform comes along that's willing to offer something better, everybody can sort of switch and port their data to the other platform, and now you'll have a new platform which will be the dominant firm in the market until another one comes along. But even if we solve that problem, that doesn't eliminate the exploitation problem, right? I mean, whether the market is contestable or not, or whether it's even highly competitive or not as a result of portability, whichever firms have your data can use it, can exploit it to help the companies that you buy from charge you higher prices, right? And so there are two separate issues at work here, I think.
I'm actually, I'm fascinated by Tom's argument that the benefits wouldn't necessarily outweigh the costs of data portability, and that switching costs is the only benefit, or reducing switching costs is the only benefit. I mean, I think the other benefit is that the new social network also gets access to a treasure trove of data on you that they can now use to target you with ads. And like, that's the business model, right? A free service, quote unquote free service where you get targeted with ads. And a startup social media company has access to basically no data. I mean, they have access to public data, but they don't have access to like all my posts going back 12 years now on Facebook, unless I'm able to move that data with me. And so you do that with X number of people, and assuming X is enough to make the business model sustainable, you have a viable competitor in the social media market then. So I think, switching costs is obviously a big one, but right now, switching costs are basically irrelevant because there's no one to switch to.
So we've been
Let me just add to say one thing. You're surprised. I haven't done the analysis, and I haven't seen anybody else who's done a general analysis of what a portability requirement, what the costs and benefits of a portability requirement would be. But I don't think it's probably straightforward, and I think it's probably quite context specific. It depends on what things you're going to port. I mean, so.
Yeah, that dovetails nicely actually to what I was going to say, which is we've just been discussing portability of social media data, which I think is a little more of a live question, like Ali stated. But there's other kinds of data that consumers should be able to port in order to reap consumer benefits, such as being able to port my financial data to a new broker. Already under this law, thorny your issues, and we don't have to bog down Congress while they figure out some other issues at hand.
So let's flesh out a little bit of what you guys have all been discussing. So you've addressed this a little bit, but does data actually affect the bargaining power of consumers vis-a-vis firms? And if so, how? And does it give the firms an advantage, or could it actually help consumers fight back, leading to no net effect? Ramsey, do you want to start off?
Well, I think it's sort of an interesting question whether data could be. So I think it's fairly obvious that data enhances the bargaining power of firms because it lets them know more about, it lets them better guess what the sort of maximum willingness to pay of consumers is for products. But it's an interesting question whether the consumers could somehow benefit from data as well, because just as there's a ton of data about consumers out there, I mean, firms now have much more data about their own costs than they ever did before. I mean, and this has actually been underway far longer than sort of the consumer data extraction side has been underway. For decades now, firms have had sort of hyper-accurate information about each product that's being scanned, at the checkout at supermarkets and so on. They've automated their supply chains. They have a much better sense of what their costs are, and that's all data that consumers, in theory, could use in bargaining with firms, because once that's sort of the flip side, the equivalent of the consumer's maximum willingness to pay, right, is the firm's minimum willingness to accept, if you will, in terms of prices. And if there were some way for consumers to leverage that information and use it against firms, then they could at least offset their loss in bargaining power associated with the data that's being extracted from them. The main challenge that's faced in making that happen, though, is that consumers are disorganized, right, relative to firms. They're atomistic and so they're not able to sort of, and they don't have any access to the data. They're not, unlike firms which are sort of observing consumers aren't out there observing firms' cost levels directly. So we would need some way first to sort of force firms to give up their data on their costs, and then we need a way to sort of centralize that information and use it in a way that consumers can exploit to hold out for lower prices from firms. And it strikes me that absent some kind of a legislative solution that was to do that, consumers are going to be sort of permanently at a bargaining disadvantage in the data economy.
So I tend to agree with Ramsey on this one. I think, pervasive data collection allows firms to develop detailed profiles about their customers and their customers' willingness to pay, which allows for personalized pricing strategies and manipulations of consumer choice, placing, very, very, very persuasive ads for particular consumers. And companies can do this at scale because of machine learning and algorithms. Individuals can't. And, it may be true that I can now plug into the internet and say, oh, I need a new shower curtain. What does it cost at Target? What does it cost at, Bed Bath & Beyond? And, price compare. But that has limited utility, particularly when, as Katie pointed out, we're often seeing personalized prices, or lately if you're searching on Amazon, sort of the sponsored things go to the top. I was trying to find, a particular cell phone case, and I couldn't even find it until I put in the brand name and exactly what it was. It didn't show up in just search for cell phone case. So if you're not seeing products because of what algorithms are doing, and you're not seeing particular prices, you really just don't have the information as an individual to leverage data against the companies.
Yeah, I think the data portability and data access is going to be hopefully a huge bargaining chip for consumers in the future. I don't think that we really have that ability now. I do think that the emerging automated car market will kind of necessitate that we answer some of these questions, right? Who has access and who has ownership of my driving data? In the past, that was you, and if you had an agreement with Progressive or some other car insurance company that put a black box in your car. In the future, we're going to want to have access to this car driving data in order to make sure that our automated driving systems are as safe as possible, but at the same time, it reveals a lot of sensitive information about users. So hopefully we want this situation between consumers and companies to be more even, and I think that as consumers have better acknowledgement of their data and where they're creating it, that hopefully they'll be able to take more ownership under a new data privacy law and use this as a bargaining chip. I also think that although we discussed a lot in the last question, I don't want to dip back in, I do think that it is a huge deal for consumers to be able to avoid lock-in with any one service, right? Consumers should be able to shop for whatever group respects their choices the most. And I think that's one of the huge issues that came out of the Equifax breach, is that consumers felt the immediate effect of this breach. Equifax really did it in the long run, and yet they have no relationship with Equifax at all. And so having some sense that you have control over your data is obviously an emerging thing in the US, and I think that in the future we're going to see more and more of consumers leveraging their data in order to get a better product or service, or hopefully maybe even change the dynamics, change the kind of services that were being offered in the first place.
So going back to the portability issue, do you think there should be a fee associated with being able to port your own data?
I would say no. I think the question of ownership rights over data is kind of a thorny one, because it's somewhat of a mutual process between you and whatever service you're interacting with. However, I think that as we saw, again, with the Equifax breach, of having to protect your data and to pay a fee for it was hugely onerous to consumers. I also think that this having a fee associated with the portability of your data could possibly prevent the change from one service to another, so it could affect some consumers more than others. In addition, I think that this already is asking for consumers to make a pretty deliberative step to take their data and move it to another, and I don't think you should put a further burden on that change.
So I agree that consumers shouldn't have to pay to port their data. The question of whether the receiving provider should have to pay is an interesting one that I haven't really thought a lot about, and what that would mean, and how much is a reasonable amount to charge for that sort of thing. I could certainly see exorbitant fees being charged, and therefore companies don't want to pay for the data. But also could see some potential benefits there as well. Good question, though. Interesting. I'll continue thinking about that.
Yeah, I guess that brings up an interesting solution. I guess it would be better if companies could organize with each other what sort of level playing field they can figure out so that consumers don't have to pay a fee. And that's actually a more, I think, conducive situation to realizing a equitable outcome.
So I feel like I'm sort of bristling a little bit at this question. So my organization comes from the philosophical, if not, certainly not the legal position, but the philosophical position that you own your own data. So if I own this information about myself that I have given over to a company, let's call it Facebook right now, and Facebook has been able to profit off of that data, so they've already gotten a lot of value out of it. It doesn't seem fair to me that I would then have to pay to get my data back. And I'm not even sure about another company having to pay for me to be able to then bring my data over and use that other company, because it seems to me that Facebook has already gotten a whole lot of value out of this thing that I philosophically, if not legally, should own. And I don't think sort of the philosophical ownership is not a controversial idea that public knowledge dreamed up. I mean, if you heard Mark Zuckerberg testify back in April over and over again, you own your own data. We believe that you own your own data, which is a really interesting thing to hear from him. So do you think that there's increasing consensus in that space from that sort of philosophical underpinning? And if that's the underpinning, I just don't see how fees get involved.
Let me just, I agree that this ownership question is obviously a difficult question, but if you analogize it like was just done in terms of you paid for the service with your data, now let's, for example, say, well, you paid for the service with money. Does that mean it's still your money?
Well, I think that's a false comparison because data is dynamic and you're always creating it, and there's always future ways that data can be used, right? Like that's one reason why companies want to make sure that they have such a large network in order to then extract the amount of data and then use the data for future purposes. I don't think that a lot of us could have anticipated the kind of growth of a lot of the properties that we gave data to in the early days of the internet and how they would use it in the future. And there's also that, I just don't think that those are comparable things, but I do understand that the payment idea maybe ruffles that a little bit.
Does data soften traditional innovation-based arguments against antitrust enforcement by ensuring that firms are able to extract greater profits from less concentrated markets and therefore to maintain R&D spending despite increased competition in their markets? Katie, do you want to respond to that?
Sure. I don't think the framing here is exactly correct. I think sound antitrust enforcement is conducive to innovation, and data doesn't soften that argument. A lot of startups use their employees' data in order to get into the market. That kind of R&D spending is already encapsulated in the startup market that we already have. In addition, you see that there's further concentration of markets, even with great use of data from employees or small data sets. The goal now for a lot of startups is to be bought by one of the big ones, which is not necessarily creating a full market where there's a lot of competition, but rather further centralization, and that's still including data. In addition, I think that the R&D spending, right, like the R&D spending here is, if it's going to be based on data, that's much smaller cost, I think, than it used to be in the past, right? Like you can create a product like Fitbit based on in the beginning, based on employee data, which was not necessarily, that doesn't change any kind of competition or antitrust arguments, in my opinion.
I think, the jury is still out on whether sort of concentration is more conducive to innovation or competition is more conducive to innovation. But if we accept the sort of argument, which I think antitrust has largely accepted since the late 70s, that some amount of sort of monopoly power or concentration can be conducive to innovation because it allows firms more profits, which they can invest in research and development. If we accept that, and we also accept that sort of the decline in antitrust enforcement that took place, starting in the 80s and which has really persisted until this day, was largely a response to the view that maybe concentration is good for innovation, and so we don't want to deny firms too much in the way of profits. The fact that data now allows firms to extract more profits from consumers, to extract more value from consumers than they did before, should raise an important question about whether therefore, sort of the balance that was struck by antitrust starting in the 80s has been upset, and now perhaps we have too much profit going to firms, and if we were to ramp up antitrust enforcement and increase competition in markets, if that were to drive prices down a bit, that would simply offset the increase in prices brought about by data and just return us to the sort of balance between consumer and producer interest that was struck starting in the 80s. And so, if we think that the sort of balance that was struck starting in the 80s was actually conducive to sort of struck the right balance between funding innovation and benefiting consumers, all we would be doing by ramping up enforcement would be returning to that balance that that both sides of the equation seem to agree was the right balance. So I think that ultimately data does sort of reduce the power of arguments that increased antitrust enforcement would harm innovation.
I mean, I agree with Ramsey that I think the economics literature that has not, there's no clear answer to the question of what type of market structure is most conducive to innovation. But we do have we do have, in the tech economy, we have, it's not only in that, but it's certainly perhaps a more prominent characteristic of the tech economy is you have these kind of winner-take-all markets and, races to be, competition for the market. And certainly one can argue that those are quite conducive to innovation. This ranges from Microsoft to Google to Facebook, and it's to a significant extent because there are large, significant network effects and other economies of scale, and consumer, when you have technologies like this where there are large network effects and economies of scale, you don't want to if you make the market more, quote, competitive or more atomistic, for want of a better word, you may very well lose those network effects, and those network effects and economies of scale benefit consumers.
Going back to the price discrimination point addressed earlier, can you talk about the difference between old-fashioned price discrimination, like charging more for flights closer to the date of departure, versus the use of modern data-driven price discrimination?
Would you just repeat the question? I want to make sure that I've got a good handle on it.
Sure, trying to understand the difference in price discrimination now because of the amount of data that is available. So before, maybe they were price discriminating based on the timing of when you bought your flight. So if you needed a last-minute flight, you paid more money. But now with all of the data that's available, they can price discriminate differently, not just at the last minute.
So one of the things that data is allowed and is sort of firms to exploit new information about changes in demand in a way that they couldn't in the past. So if you think about, in the past, a firm might set one price and then after a month or two, could look at the, would look at that price again and have more information about, how many orders were coming in, for example, and then change the price in response. Today, a firm can do that almost in real time because it has information about, for example, it might be getting information through its website about how many consumers are coming to the website, and it has a history associated with that tells it that when the number of consumers coming to the website goes up, generally the willingness to pay goes up as well, and firms could have even tested that by varying price in response to these factors to come up with a robust result. What that means is firms now can change prices much more quickly than output would be able to adjust. So if you think about going back to the firm that had to wait a month before it could change prices, it might be in an industry in which production can also be varied over that time scale. And as a result of that, today when prices change, supply is generally fixed for firms. And so when they raises prices, it's basically acting as a rationer. It's rationing access to a good that's in fixed supply. And so it's able to use the price increase to extract more value from firms. In the past, when the demand went up over that time period, it would simply sell out of the good. And from an efficiency perspective, it doesn't matter whether the good sells out or whether the good is rationed based on price, because supply doesn't change over those periods. But from a distributional perspective, there is a big difference, because when price goes up, consumers end up paying more for the good than they would if the good had just sold out under sort of the old regime in which firms couldn't vary price.
So
Yeah, I
take it out of the economics for a second. There's sort of the old-fashioned dynamic pricing. The airplane ticket gets more expensive as we get closer to the flight. And that, and that is true if you're buying the plane ticket from, DuPont Circle or from Anacostia, right? It doesn't care who you are. It cares about the day that you are buying the ticket. And I think many of us find that less problematic. Then there's sort of the dynamic pricing we're seeing today, which is there's all this data about me as an individual. And so I live in DuPont Circle and I'm a lawyer, and they've got all of this data, and they say, and she really wants to go to New York, so I bet she'll pay more for the ticket. Whereas, someone else who, maybe it's because they can pay less, and, some of us might think that that's actually a good outcome. But maybe it's because, they've sort of figured out by data profiling this person that they don't really want to go on this trip, or they don't, whatever the conditions are, and they're given a cheaper ticket. And it's not, it's personalized pricing now, personalized dynamic pricing, as distinguished from sort of the price increases for everyone because we are closer to the time of the flight, since we're using airplanes.
Yeah, I think it's kind of following up on that. I think it's, at least conceptually, it's important to distinguish between two things. One is, I think, what's normally called price discrimination, which is basically based on differences in demand and differences in willingness to pay. It's also the basis for public utility, for efficient public utility price regulation. What's called Ramsey pricing. So that's one element. It's based on now the thing about filling empty airline seats is really a different phenomenon. It's just you get close to the flight and half the plane's empty, and you lower the price to try to sell those tickets. That's really kind of a different phenomenon. As is, for example, Uber surge pricing. If there's a big increase in demand at whatever it is at 5 o'clock, to ration the available Ubers, they may raise the price, but that's different than price discrimination.
Well, I like to distinguish between, so I define dynamic pricing as really the adjusting of price based on new information. Whereas price discrimination, which can happen dynamically in the sense that it's going to involve charging different prices at different times depending on who the customer is pricing that's based on sort of prior information about the profile of the consumer, a group of consumers, her coming to buy at that particular time. I think that may be a useful way to distinguish the phenomena, because both when you price discriminate, unless everybody comes to buy at the same time, you're going to be charging different prices at different times. But you're doing something slightly different from dynamic pricing, which is where you're able to sort of incorporate new information and change price in real time.
Well, I think price discrimination is really based on differences in demand elasticities, willingness to pay. I don't know exactly what's now included in dynamic pricing, but the other phenomenon is really based on what's a disequilibrium in the market. There's either an excess demand or an excess supply, and the price is moving to try to move towards equilibrium.
So with our time left, we will switch gears a little bit. So many companies and NTIA have been calling for a risk-based approach to comprehensive privacy legislation that would base the rules and remedies on the sensitivity of the personal information involved and the risks associated with breach, disclosure, or misuse. What are your reactions to that approach? And Tom, do you want to start us off?
Sure. Well, obviously, risk is an important element in the whole thing. I guess what I think I think any new approach needs to yield net benefits relative to the status quo, and the status quo really is the current FTC approach of ex post, case-by-case, enforcement-based privacy regulation, and I think it's, obviously there's disagreement about that, but I think it's a pretty good approach. And since it's, as I said before, benefits by definition consist in a reduction in harms, you need to start out by identifying the harms you're aiming anything new at in order to get any estimate of benefits, and then if there are benefits, you need to assure that the benefits are sufficient to outweigh the costs. There's another element in the end. I think there were two elements that I read that were kind of stood out in the NTIA document. One was the risk-based approach, and the other was what they call their focus on outcomes. That they want to focus on outcomes rather than dictate specific practices, which I think could be a good thing if what they mean is something like a performance standard, like in the environmental context. So, performance standard would say, well, we're gonna set the maximum level of pollution for a plant and let the plant figure out how to do that in the most cost-effective way. Well, can be an efficient way to do it. And then the relevant outcome should be a reduction in privacy harms. But I think what the NTIA calls outcomes, I really think of as inputs. I mean, they call outcomes things like transparency, access, and control. I think they're really inputs, and they're supposed to produce privacy benefits. But they don't really explain how that happens, how those inputs are going to produce privacy benefits, because they don't really talk about privacy harms.
Sure. So I want to build on Tom's discussion of harms. So when I hear risk-based approach, I hear the industry saying, hey, we only want to be held accountable for legally cognizable harms. That may sound great, but it's actually really hard in the case of privacy to prove legally cognizable harms. That's usually like financial injury or physical injury. And often when it's financial loss, it's really, really hard to trace back to the source. Was your credit card number stolen because of Target's breach or Home Depot's breach or, I don't know, Lord & Taylor's breach, right? Tracing it back. Even if you could trace it back, often your bank is going to pick up the damage, so you're not going to have any financial loss. So there's not going to be a legally cognizable harm. But there are a number of harms that come from from misuse of data, from data breach. There are a number of sort of non-legally cognizable harms that we need to take into account. So this can be embarrassment or reputational harms that jeopardize job or social opportunities. Those could be re-endangering a domestic violence victim when her data are accessed by her former stalker or her former abusive partner. That could be not having access to opportunities because the data said you shouldn't be shown this particular ad for housing or this particular ad for a senior management position. This could be informational harms. So, the fragmented news, fake news. They could be things like Cambridge Analytica influencing people in the voting booth. And that's not to say that privacy legislation or regulations should solve all of these major societal problems, but it is to say that when we think about what harms we are addressing, we need to think really, really broadly about what those harms are. Second of all, when we talk about sensitive, non-sensitive information, so many folks, particularly our friends in industry, say, oh, yes, we want to protect privacy, but only for sensitive information. And by that they mean first and last name, credit card information, maybe your health status, maybe protected class status. But everything else should be fair game. And in today's world, it is so trivial. First of all, so-called non-sensitive information in the aggregate or even point by point can in fact reveal very sensitive information. So take, for example, health status, often a sensitive category. So the fact that someone has cancer, probably sensitive. There are probably restrictions there. Shopping history, usually non-sensitive. But if someone is shopping at headcovers.com or TLC Direct, those are both websites that specialize almost exclusively in hats for chemotherapy patients. That information likely reveals health status and can be used as a very, very effective proxy to advertise based on or discriminate based on or, sort of fill in the blank based on health status. Also, non-sensitive information is often used for very sensitive purposes. So if you believe Cambridge Analytica, or for that matter, the Obama campaign, which used very, very sophisticated, I think I heard a presentation, don't hold me to the potato chip types, where they had, figured out whether you liked Cheetos or Doritos meant you were more likely to vote Democrat or Republican. No one's going to make your chip preference sensitive. But if it's being used to influence you in the voting booth, maybe it is sensitive. So, I would encourage, as we're thinking about privacy in the digital age, that the sensitive, non-sensitive distinction really, in the age of big data, no longer makes sense.
So I'd just like to jump in on that. To take it back to the NTIA's risk-based approach here, we disagree entirely with the framing. Privacy, consumers always have a privacy interest in their data. Once it's in the hands of another, they have an interest in how that data is used, possibly breached, and how it is later passed to another party. So we'd rather that the NTIA use more of a focus that we've seen in other privacy laws like the Wiretap Act or the Video Privacy Protection Act, where the invasion of privacy was a de facto harm, and we would suggest that that's the framing here for the NTIA, and that will be in our comments that we will submit tomorrow. In addition, we really encourage a broad sense of what consumer privacy harm is. As Ali mentioned, it's really hard to trace back the consumer harm to one specific breach or another, but we do know that consumers experience a large amount of financial and identity theft and reputational harm based on the huge number of breaches in the past few years. And we think a privacy law should recalculate the incentives for businesses so that they actually take into account consumer data privacy and protect the data that they have either been entrusted with or for whatever reason now have control over, in order to make sure that consumer data privacy is respected just as much as whatever other incentives that whatever other priorities that the business has. Thanks.
With our last 2 minutes, does anyone want to have any last thoughts before we end our panel?
Sure. So I think it's fairly obvious that consumers are not in a position to make sort of optimal choices about how their data is used. Right? It requires a level of knowledge that I think it's unfair to require of individual consumers. And it's also the case that data leads to efficiency benefits, things that consumers like. And so the question is whether if we can't sort of create a market-based solution for the problem of extraction of data, perhaps we can create a market-based solution for the problem of exploitation of data for purposes of harming consumers. And one way to do that would be to promote much more competitive markets across the board in the economy today than we currently have, in my view.
To pick up on something else, actually, there's really the data available on privacy harms is really pretty inadequate. I mean, even the most tangible types of privacy harms, like identity theft, identity fraud, there's really not very good data. There's a paper a year or so ago by Josephine Wolf and Bill Lair, which makes that point, and it's, having looked for the data over the years, it's pretty sparse. Both the FTC and the NTIA have said that they want to promote research in these areas, so this might be one thing to do.
Well, thank you all for your valuable insights and for being on the panel. We will be taking a short break now and then starting back again promptly at 10:45. Thank you.
I really enjoyed your remarks. I really enjoyed your remarks.
yours.
Yeah.